And who is one word plus? Oh my gosh. Is this an attorney? Why doesn't he have on any clothes? Who is this Roland person?
This is a very serious thing. I don't know how you set 6 grown men at that one little table.
You're all gonna have to squeeze in.
Something influenced her decision. She changed it and she sent him to TDC afterwards. I think it was a phone call to her mother.
With regards to Mr. Goss sitting there, he hasn't been qualified for the jury.
Clip, Judge Boyd grills me for about 9 minutes.
Was installing a big screen TV on the wall of the judge's mom's house back in Louisiana so she could watch her daughter in court every day.
State, do you have any objections to him sitting?
Yes, Your Honor, the state objects to Mr. Goss sitting.
Your Honor, may I respond to that? I am his counsel of record. I have been entered as his counsel of record, and the state's right to not have me sit there does not supersede his constitutional right to have counsel and effective assistance of counsel, including counsel of his choice. Also,
Why are you not here in the beginning during jury selection if you are his counsel of record?
Your Honor, I, along with Jay Norton, Nico LaHood, Patrick Ballantyne, Jasmine Olguin, and Gary Hillier are all his counsels of record who have entered a notice of
My
appearance.
question is, why were you not present during jury selection? This is the first time that you have been a part of this jury trial. So my question is, why were you not present during jury selection? Why have you not been present during the state's case in chief? Why are you just now making an appearance?
Yes, Your Honor. So I had other matters that I had to attend to. This was Mr. Hillier's case along with Ms. Olguin. The state represented to the court that it would be a 3 or 4 day trial. Mr. Hillier repeatedly tried to tell the court that it would not. Mr. Hillier repeatedly asked for continuances based upon this vacation. Mr. Hillier put in a vacation letter and told the court that if it went longer than last week, then it would run into his vacation.
And a vacation letter does not a motion for continuance make. And this was the date that was chosen by the parties. This case had been reset before because counsel said he had a CLE to attend. So the court gave him time to attend his CLE, and this is the date that both parties chose.
And the court
And he's in the middle of a trial. And then we go back to the question is, if you're going to be his attorney, why were you not here during any parts of this trial? This is the first time that you've appeared to sit. And if Mr. Hillier knew he was not going to be here, why did he not have you qualified before the jury? It would have been a simple matter of his asking the jury, we're going to have Jason Goss who may come sit with us. Does anybody know Jason Goss?
Mr. Hillier believed based upon when the court set this case, if the court remembers, the court set it for last Monday. The court decided not to go to trial last Monday.
Because he said that he had a CLE to attend where he was seeking to obtain his board certification.
No, Your Honor, the week before. That was the week before. Last Monday was when this trial started. The court told the parties that they would start on Monday and be here Monday. The court decided not to start until Tuesday. Had the court started on Monday, Mr. Hillier would have been here today. I mean, the case would have been over on Friday.
Mr. Hillier had a choice to make. He chose to go on his vacation.
Your Honor, the reason that there are vacation letters is because the courts have recognized that it is not a choice when somebody has a family, when they have non-refundable tickets, when they have plans that have been made for over a year's time. In addition to, he is not in a position where he could join them late because they are on a ship in the middle of the ocean. So he is not in a position that he could leave his family.
So you're telling me that cruises do not dock in different places?
They perhaps dock in different places, but he could not make half of the vacation with his family and was not willing to have his family go along without him. And that is why there are vacation letters. So the defense is asking for a continuance to allow Mr. Hillier back.
Oh, that's going to be denied.
I understand. And additionally,
And have you filed a motion for continuance?
defense is asking for a continuance from the court at this time based upon these circumstances.
So you have not filed a motion for continuance, is that correct?
We will file a motion for continuance.
No, my question is, have you filed a motion for continuance?
The motion for continuance was filed before and it was denied.
Have you filed a motion for continuance? We're in the middle of a trial. Have you filed a motion for continuance now?
We have not. We will.
That will be denied.
Yes, Your Honor.
All right, so the issue is whether or not State, do you object to this counsel being present?
Yes, Your Honor, the state objects.
And based, as I argued before, they do not have the right to have a question about whether somebody on the jury might recognize me or look at me and know who I am. That right does not supersede my client's right to counsel of his choice and to effective representation of counsel.
Well, the counsel he chose was obviously Mr. Hilliard because he was here, Ms. O'Gean was here. So those are the two counsels he chose from your firm. And we're back to the point. Why did you not appear for any stage of this trial before now?
Because the court and the state represented that the case would be done last week, and it was not. So based upon those representations made by the state, 3 or 4 days, which is on video and on the record, and the court, who believed that it would be done last week, I had other settings that I had to go and appear at. And so
Other settings that were jury trials?
other settings that were potential jury trials that didn't turn out to be jury
So
trials.
not jury trials.
Not jury trials, Your Honor. However, in this situation, the state objecting in this situation to me sitting and assisting Ms. Olguin is that right is so low on the totem pole compared to his right to allow me to sit here and assist Ms. Olguin.
So hypothetically, let's say somebody from the state's office were to come down to sit there and they haven't been qualified before the jury.
Right.
And you say, oh, that's fine. And then we discover, oh, their mom is on the jury. That
Right.
would be fine with you.
Well, I know my mother's not on this.
No, that's I'm giving you a
The
hypothetical.
state does not have a constitutional right to
I'm
counsel.
giving you a
The state
hypothetical.
does not have a Sixth Amendment right to
So
counsel.
let me ask you this. So let's assume your mom is on this jury. Do you think that you should still be allowed to sit? Let's assume one of your best friends is on the jury. Do you think that would be a fair trial for the state for you to sit?
I think
Yes
that-
or no?
I think that their issue with that would not outweigh his Sixth Amendment right. It's a
Okay.
constitutional right versus the state's disagreement or some possibility that does not exist.
Mhm.
So no, my mother and my best friend are not on this jury.
Well, you wouldn't know that.
Well, so I would definitely know if my mother was,
Mhm.
right? So, and she's not, because I know where she is and she's not serving on this jury. As far as the other balance, it's just a balance of rights. I mean, I am here, I am willing to assist Ms. Olguin. It is important for my client's rights and the Sixth Amendment right to allow me to do that.
All right, are the jurors present? All right, let's line them up.
In the case with Jasmine Olguin, who is an associate in our firm. She has been licensed in November, she'll be licensed for 2 years. And while I was sitting with Ms. Olguin on that case, I was told several times by Judge Boyd in front of the jury that I was not allowed to speak, that Jasmine was my lead counsel, and that I could not make arguments on the issue that we were trying to argue. Of course, I objected, and at the time the case worked out for us, but I had issue with that, and then I had to basically transmit arguments and things on some of those issues through counsel, through Jasmine, which told me, just based by her conduct in that case, that she was not treating me as she would treat other lawyers who are senior lawyers who are sitting on the case and should be allowed to make arguments on behalf of their clients. And that occurred last month. So that case was what was happening last month.
If you look on the screen, I have the slide I displayed earlier. Is that slide and the video clip that accompanies it, is that from the case you're talking about?
Yes. Yes, I had to come in as counsel because one of our other counsels who had informed the court that he was on a non-refundable vacation, the court started the trial anyway, knowing that it would not be done a week, and she was told it would not be done a week. She made our associate and Jasmine go to trial. Subsequently, when the case did go longer than a week and he had to go on the vacation because it had been planned for over a year, and it was non-refundable, I came in. I had to come in because there would only be left with Jasmine, who had not tried a manslaughter, who was not she is a very capable lawyer, but she is a very capable lawyer and a great lawyer at the beginning of her career. So in that clip, Judge Boyd grills me for about 9 minutes, ultimately bringing the jury in, asking them if they recognize me, and then allowing me to sit. Only after I went through this, this performative, I think, questioning, and honestly with the intent to disparage or humiliate me, she finally allowed that after going through all of that.
I've extended an offer to this defense, Your Honor. Don't
Yeah, no.
believe they're accepting.
Yes, y'all want a jury trial?
We do, Judge.
All right, Ms. Ferguson, I need a jury trial date. How long is this trial going to last?
Logistically, I could say in upwards of 3 weeks. Judge.
No. How many witnesses y'all have?
State anticipates, of my initial witnesses, approximately 25 right now.
All right, so some of those witnesses, I don't think they're probably going to be 25.
Judge, can I speak
Yes.
on it a little bit?
Mhm.
There's a joint defense agreement in this case.
Mhm.
So when I say logistics, I'm referring to not only space, but also time. We're gonna have to accomplish a counsel table or an area that can accommodate 3 lawyer teams and their respective clients.
All right, so when you all say 3 lawyer teams, I can tell you all the space, turn around, the space that you see in this courtroom is the space that you will have. So if lawyer teams want to bring paralegals and everybody else, they're going to be sitting somewhere in the gallery.
Well, let's just assume for a moment that there's 1 lawyer with each client. We know there to be more. I don't know how you set 6 grown men at that one little table.
You're all
just
gonna have
putting
to
it before
squeeze
the
in.
court.
I understand. You guys will have to squeeze in. Guess what? This is what the county has available. This is what the county is paid for.
Which is why we're bringing it up. We're curious what else the county has available. Other
Oh,
courtrooms
just
that are
this.
larger entities. Well, I think there's other ones, and so we'd like to explore those possibilities. We wouldn't want it to prejudice the clients or the presentation of the evidence at all. So we're putting it before the court early, in earnest, wanting to be candid with the tribunal and then hopefully
I
find.
appreciate that, but what I will tell you all is judges rarely, if ever, agree to switch courts. So this is where we are. Yes.
And Your Honor, I do not mean to interrupt. I do have an issue that has been pursued. As the court know, we met the discovery deadline at the end of May. There has been an issue that the state had been rebuffed with records of the deceased, the complainant, from a private facility in Kerrville. My office has continued communications with them, and as of 2 days ago, they finally understood that the state of the deceased is not being attacked by this prosecution, and they will have agreed to release the records to me if I get a judicial order signed. I filed this yesterday in the name of defendant Flores. I've let counsel know. I'd like to urge this, and I will share with every defendant if they produce the records of the complainant's residence at Starlight Recovery. I don't believe it's dispositive of any issue, but I do know defendants are interested in it. And I don't mean, sorry for interrupting, I probably should have led with that first, Judge.
All right, Ms. Ferguson, this trial is going to take 2 weeks. Give me a jury trial setting for 2 weeks, please.
And would the court, once we have the initial setting, would the court be willing to entertain this case with all 3 defendants? Is specific to my docket. I already have a scheduling order on a different matter, same gravity in another court that I've got to try and align. Is the only reason I'm bringing it up. Judge.
All right, is that other case actually going to go in the other court?
Yes, ma'am. I'm in the 437th with the LaHood firm, who's also co-counsel in this. We have a pre-trial motion set in mid-September, and we have a firm trial date in November.
And which court is, you say the 437?
Yes, ma'am.
All right, we'll see if that goes. Ms. Ferguson, give me a date.
Would the court be open to scheduling orders? The parties had discussed whether we could get together, check the calendars of the experts the witnesses and the lawyers and propose a scheduling order to the court?
No. Court is not doing a scheduling order for this. This is gonna be your trial date. If y'all have motions that need to be heard before trial, set it with Ms. Ferguson and the court will be available to hear it. All right, and y'all can set that, Ms. Ferguson, if they have motions, it can be set on a Friday. All right, September 24th.
So I'm hearing the court to say of the lawyer teams and the experts that have been retained in this case, we will not be afforded a chance to see if everybody's schedule can comply with that date. You're setting that as a hard date.
Yeah, it's September 24th. All right. Is there anything else?
Yes, Your Honor, if I could approach with
Yes.
a copy of the order. And for the court's information, the order is obviously the last page. The attachment is the email and language from the Starlight Recovery saying they require the court order to comply with meet HIPAA requirements.
In the court when the YouTube thing started,
Yes.
okay, can you talk about whether that you saw a change in Judge Boyd's judicial behavior upon that evidence?
I would say yes. The technology curve improved here in Bexar County as a whole, but this particular court used the picture-in-picture frame to show the judge while it's also showing whichever litigant was speaking at the time, which is unique and different than other courts. And that the fact that you get gently reprimanded based on how you move around in the courtroom to try to keep you within the camera shot, which is in the well. If you turn your back to the camera, you're told that the court reporter can't hear you, but she can. Things like that.
Can you tell us about the scene that Judge Boyd sets every morning with regards to the camera that is facing her?
Sure, she goes through her comments, right? She sets up her handbag next to her flower display, and she goes through a series of, I'm going to call them ovations. Most have jest packed into them to get laughs, either online or in the courtroom, before she actually calls the docket and begins serious business. There was a case that should have been a VTC acceptance.
And that's Veterans Treatment Court.
Yeah.
Correct.
The case actually belonged to Mr. Goss. The judge was going to, I think, grant a application for probation. And I'm going to say after something influenced her decision, she changed it and she sent him to TDC afterwards, I think for 4 years.
And do you have any knowledge of what it was that changed her decision?
I think it was a phone call to her mother.
Why would
I'd
you
like
call-
to speak to that a little bit.
Yes, sir.
It was known to me that part of the YouTube genesis in this courtroom was installing a big screen TV on the wall of the judge's mom's house back in Louisiana so she could watch her daughter in court every day, kind of like a TV show. And that it began to create content, and that the content obviously started to take off online. And so it was my impression that the TV show, as it were, and somebody watching at home influenced the outcome of that punishment trial that day.
Well, I think the state has an issue that they want to talk to you about. So I don't think they want to ask for any time for 4 years.
Oh, no, this is going.
Well, I think they've got a legitimate argument. And I hate to say that, but I think it's a fair argument.
Judge, so, and I guess we were gonna have this hearing closer whenever we were about to go on this. So we subpoenaed 2 witnesses in this case yesterday. We have a jail call last night from the defendant telling these witnesses not to appear.
All right, that sounds like forfeiture by wrongdoing. So the confrontation clause doesn't apply. So what's the issue?
So that was just something that we were just gonna file a motion, Judge. I just hadn't had the time to work.
Oh,
on it,
okay.
Just because it was pretty short notice. And we had just uploaded the jail call just because it happened
Okay.
last night.
All
Well,
right.
I mean, this is new information to me. And this changes my way of doing the case, and I am not ready based on that information.
All right, we're going forward. If somebody makes a jail call allegedly last night, this wasn't a jail call that has been sitting around forever. If it's a jail call that was made last night, state wouldn't know about it until they looked at it.
And I wouldn't know about it until this morning.
So you all are on notice. He's alleged to have made a phone call. You have it. Have you turned it over to the defense?
My understanding is that our paralegal uploaded it in the case this morning.
Just have them give it to him now. Let him listen to it. Let his client listen to it. This case is going to trial. He's been in jail and this is 5 settings, so it's going.
Judge, the only other thing, so we did get discovery, there was a co-defendant in this case. The discovery mainly pertains to the co-defendant. That's what I've been uploading this morning as well, but we weren't going to use any of the co-defendant items.
This is going to trial today.
So let me just be clear. I'll need to make a record. I believe the state of the law is I'm entitled to time to prepare for a trial. I believe that's under the due process costs and due course of law.
Mhm.
I have not had time to do that. It will adversely affect my client. I understand you have the absolute right as a trial judge to call my case. I cannot keep you from doing it.
Mhm.
I don't prefer to do things twice.
Yeah.
So that's why I'm
This-
raising the issue. with
I
you.
understand what issue you're raising. This is going to trial. If he made a phone call allegedly
Well, I don't know.
recently, well, we're gonna find out. They're gonna give you the phone call. He'll be able to listen to the phone call. But if he made a phone call last night and it's something new that they didn't know about beforehand and they're just getting it, it's going. So
That's an interesting interpretation of the law.
I know, I appreciate the interesting interpretation, but that's what happens when clients make phone calls from the jail and think that the phone calls are not recorded. When it clearly says when somebody's making a phone call, this phone call is being recorded. And then the person on the receiving end of the
Judge,
phone call.
I
it
understand the
says that.
argument. I'm simply telling you as a litigator
Mhm.
that it changes the trial strategy. I believe it does affect his due process rights, and I will want to make that
Well,
absolutely, as they put it, there is no other kind of clear but crystal on the record.
oh,
And then you may overrule that.
Yeah.
I may then cite the case law that tells you you're wrong. You may ignore that and then.
Oh, let me just tell you what's gonna end up happening. I'm not hearing any motions for continuance unless a motion for continuance is filed and filed properly. And number two,
Well, now, how
once
would
that-
how would I do it in writing when I just found out about it? All right, so I will go back to the office and I will prepare that motion for continuance and I will
and
do
then
that.
I will hear it. And if I'm telling everybody, if that motion for continuance is based upon a phone call that he made last night, this trial is going. All right,
Okay,
who's
well-
here on Janelle Williams?
What I do know is that I am now being placed in a position where I haven't looked at what they're saying. It isn't whether they're going to present it, it's whether it's material to our defense. And I don't know, Judge, but what I do know is that I prepared by uploading each and everything in the case to this drive. And when there's additional information, I'm very concerned about going forward. It's the whole reason that we signed those discovery acknowledgements, which I cannot sign today.
But what he's saying is that it's already been uploaded. And it wasn't just uploaded today, that you already have it.
Well, everything that is on this drive is what has been uploaded in this case, and I am on notice that we are trying today. I believe that evidence might be to another case, might be somewhere else. But I asked them, and I've been in open court and said it, I want every piece of information on this case. So if they're intending on bringing information from other cases, that was the reason that I went here today and said, what case are we trying? And I want to be prepared on it. On the the forfeiture thing, I actually pulled the number of subpoenas that have been done. Today I went to the district clerks
Mhm.
and there's only one subpoena requested on file on this case. I have a copy for the court. It's on Emily Rose Fritz, which is none of these individuals, and there's a return on her. So if there has been a subpoena done, I wasn't on notice of it. Of course, what I would have done is I would have discussed with Mr. Estrada, you can't mess with the witnesses. But I can only prepare him for what is in the records. In other words, there is no record of these people either being a subpoena being requested or issued.
So is your argument that if there are witnesses in a case, unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not, you don't have to show up, but tell them not to show up. That's what the allegation is, that he told a witness not to show up. Not that you don't have to show up. I've been a defense attorney and I know that people have told people, hey, you haven't been subpoenaed. You can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up, or either they're going to want to do an attachment.
So I am returning to what I know to be the law. And the law is that we are entitled to two things. Number one, all the discovery on a case that we've.
I'm talking about the asset,
Yeah.
the forfeiture.
So the forfeiture by wrongdoing,
Mhm.
I do not know whether, because and I have a case here that the standard is that it has to be wrongful, right? And so the question is it wrongful? Well,
Well, the question is it wrongful to tell somebody that they don't have to, that they don't show up to court? Is that wrongful to tell somebody, do not show up to court? If you show up to court, then I'm looking at 25 years. Is that wrong to do?
I believe that is the question. If that is in fact what it said, which of course is the real problem we have here. So what I don't like to do is I don't like to be at the last minute. They're saying it's in some other discovery. I don't know that.
No. I want to talk about this forfeiture by wrongdoing. That's what I want to talk about.
Yes, ma'am.
So let's figure that out. And then we'll come back to this discovery issue.
Okay.
So that's my question. So basically, and I don't know if this is your argument or not. So are you saying that if there's somebody in custody or not in custody on bond? Well, no, let's say they're in custody. That to get out of a trial, all they have to do is, if your trial is on, let's say hypothetically, February 6th, you can call somebody on February 5th and tell them not to show. And then the defense attorney can say, excuse me, I need more time. I'm just learning about this. And then let's say hypothetically, that person gets a continuance and their continuance is, let's say it's for March 12th or whatever. I'm just doing a date. And so that defendant knows their court date, their trial is set for March 12th. So they say, you know what? Let me make a phone call. And they make a phone call on March 11th, telling somebody not to show up for court, because if you show up for court, things are not going to go well for me. And then the defense attorney can come in and say, hey, I just learned about this last night. So are we going to do a situation, hypothetically, where defendants are allowed to call people the night before their trial, tell them not to show up for trial, and then everybody gets a continuance because I'm just learning that they told somebody not to show up for trial? And these are just questions I have, Mr. Estrada, and these are hypothetical questions. I'm not saying you did that. I don't know. No evidence has been presented of me, but I'm just trying to figure out everybody's legal thoughts on certain situations.
Judge, I started out a long time ago thinking I knew everything about the law.
Mhm.
I have been dispossessed about that idea.
Oh, me too.
The answer is I don't know.
Mhm.
And when I say I don't know, I'm being straightforward and honest with you. I do not know the status of the law. I do not know the status of the subpoenas. I don't know this issue. And this issue popped up at the last moment. And it did pop up at the last moment.
Well, Mr. Bravinik, not to interrupt, but I will tell you, I know the law on that unless it's changed. You know why I know the law on that? Because when I was a prosecutor, and Ms. Ferguson will tell you, on family violence cases, you would think you have a witness, they've been subpoenaed, then all of a sudden they don't show up. You check jail calls, and the night before, whoever the defendant is has called that person and said, do not show up to court. If you don't show up to court, they're going to have to dismiss the case. And you know what I would do? I would play the DVD in court and say, here's your motion. I'm doing an affidavit. I'm doing a forfeiture.
The law
by
didn't
wrongdoing.
change, in fact, since you've been a prosecutor, because I know you've been a judge at least 4 years, right?
Yeah, more than that. But
Okay.
I always try to keep up to date on law. So
Well,
I reviewed it.
so your specific hypothetical was about when you were a prosecutor and you knew the knowledge was from back.
Oh, but here's the thing. I'm telling you that because I have background and forfeiture by wrongdoing, and I always keep up on forfeiture by wrongdoing. And the reason why I do that is because I'm anticipating that usually that happens in family violence cases. So I always check the law every now and then. And then, hey, who knows? Maybe something's changed since yesterday. If it has, I'm willing to be presented with that and keep an open mind on it. I'm always for following the law.
Well, so it has changed since you were prosecutor, which is where you let me know, and it changed in 2021.
Mhm.
I can't tell you in this specific fact because I've done not a briefing. But you had already indicated to me off the record that you were not going to grant a continuance on this particular
No,
ground.
not on, not because you've got new information that your client allegedly called someone from the jail last night on the 5th, at least that's what's in your motion too, on the 5th, I believe, asking somebody not to appear for trial.
But Judge, as you know, when I wrote this, I hadn't listened to the audio tape yet.
Okay.
So it's very difficult for me to make a good legal argument when I have yet to look over the things or read the things. Which really brings, since you had already told me you weren't going to grant a continuance on the thing that you are now indicating you're not going to the grounds that you should grant a continuance, which is that I don't know, they're telling me there's new discovery that they don't believe is material. I'm telling the court I don't know. I'm also telling the court I prepared. I'm telling the court I downloaded everything. I'm telling the court that now with this new information under Michael Morton and under the Texas Supreme Court cases, I believe I'm entitled to time to review it. And I'm not asking, I've been a trial lawyer 24 years, which I believe is a little less than you, but I'm not asking for a lot of time. I believe in a week I could be here standing and say, Judge, I'm ready, they were right. Or Judge, we've got an issue. And if there's an issue, I'll come by on Wednesday, Thursday, Friday, as soon as I can. In other words, I'm not going to let it sit out there. But at this point in my career, I am unwilling to take the other side telling me that something is not material to my client's case and is not important.
You're coming back tomorrow for trial. That's the time you have. So whatever he needs to see, he needs to see it.
Yes, Judge.
If he needs to listen to that video, the audio from the jail, he needs to listen to the audio from the jail about your request for forfeiture by wrongdoing. Y'all are here, listen to it, but you're coming back to trial for tomorrow.
Common sense says that. If you are driving at the speed Mr. Escobar says he is, and you're driving into parked traffic, you're trying to kill yourself.
Sustained,
You're trying to kill yourself.
sustained.
And that defies common sense. You see, I'm right. That's why he's objecting.
All right. All right, number one, the objection is sustained. Ladies and gentlemen of the jury, that's an improper argument. These are opening statements. Both parties are to inform you of what they expect the evidence to show you. And state your objection is sustained.
About why this happened. Why this happened, because there's only one person sitting in that chair today, and he's not the only one responsible for this. His actions are by definition not reckless. If anything, he ought to have known. He ought to have known. But to say that he knew and then he disregarded it means he's driving into a brick wall at 90 miles an hour. That makes no sense. Shana Alasso's the first domino. The police officers are the second in their investigation, failing to warn, failing to do anything to protect Alexandra Siebert. And she's a good person. I never met her. I've seen a lot of evidence about her. She did nothing wrong. It's a tragic thing. And you're going to hear, and it's
Sustained.
Judge, it's opening statement. It is
All right, oh, counsel. When I
Thank you,
make
Judge.
my ruling,
I'll
those are
move
my
on, Judge.
rulings. So
And the
the
evidence
objection is sustained.
Thank you, Judge. I'm sorry. The evidence that you're going to see, the evidence will show that this is heartbreaking. You're going to see things. You're going to see things. I want you to be prepared for that. You're going to see things that are going to break your heart. They are. It's going to hurt your heart when you see it. It is. But remember these dominoes. Go back to the law. The state is going to try and make you see these vehicles outside. The evidence is going to show, the state is going to show you these vehicles outside in the parking lot. It's just the truth. And it's going to be shocking. I'm going to tell you now, it's going to be shocking. It's going to hurt your heart. But please use your common sense. Please follow the law, because you know the first domino in this case is Shana Alassel. She's not here. She was driven home by the police after driving drunk the wrong way down the highway. The second domino in this case is the police failing to warn anyone. And the third one is the only one that they've got. He's sitting here, is Alex Castro, and he's not negligent. He's not reckless. If anything, he's negligent.
Sustained.
I'm going to ask you to find him not guilty. Thank you.
All right, thank you. All right, ladies and gentlemen, I'm just gonna have you all step outside in the hallway. Just give me 2 minutes, okay? All right, everyone, please rise for the jurors. Tell both sides. I understand sometimes passions run high and that everyone is trying to advocate their side. But this is what is not going to happen. And I want people to hear me and internalize what I'm saying. Number one, there are going to be legal objections. I'm going to hear the legal objection and I'm going to make my ruling. And once I make my ruling on the legal objection, there is not going to be a comeback at me that is a response that is not legal. So counsel, this whole thing where the state is objecting, saying it's argumentative, and I rule on it, the comeback answer is, no, it's not argumentative, judge. It's like, everyone, keep your levels here, make your objections, I will rule on them. Once I rule on the objection, guess what? That's my ruling. Unless you have something new for me to hear, that's my ruling. And if you feel that my ruling is not correct, then that's what the Court of Appeals are for. That's what the Fourth Court is for, the 13th Supreme Court, wherever you want to take it. But I will tell you what I discovered in my experience trying both as a prosecutor and a defense attorney. The jurors just want to be here. They want to hear what the story is and hear what the facts is. But if there's this back and forth where people are tending to get into the point where it's disrespectful, then we're going to be in a different place and I'm going to respond differently. So in this court, I like everyone to treat everybody with kindness and respect because that's the way you don't have tempers flaring, because all the cases in felony court, these are very serious cases where potentially sometimes people are looking at prison. You have complainants' families who may be upset. I don't want their tempers to flare. You have the accused families who may feel like, you know, their family member, their loved one should not be here. So they have tempers as well. So I'm depending on attorneys. You're all professional. You should keep it here. Does everyone understand?
Yes, Your Honor. Yes, Your Honor.
Yes, Judge.
All right, so the rule has been invoked. So state, if you can make sure that your witnesses know the rule has been invoked. So if there's anyone who's in the courtroom for the state or the defense who's planning on testifying, now is the time where you can no longer be in this courtroom. They've done their opening statements. Witnesses are going to be called. And if people who are planning on testifying view anything or in the courtroom or talk to people about testimony that they've heard, what's going to end up happening if it's discovered, I will probably end up hearing motions from either the state or the defense asking that someone not be allowed to testify. Does everyone understand?
Yes, Your Honor.
Yes, Your Honor.
All right. The other housekeeping matter, again, if people are putting things on easels, if people are taking papers to people, defense attorney, state attorney, if y'all need to move around to see it, you don't have to ask permission. You don't have to ask permission to approach a witness. But remember, when you approach the witness, after you have finished approaching the witness, which whatever you want them to see, please have a seat. All right. And Laura Metzel, did you have something for me to sign? All right, I'm going to take this up, then we're going to bring the jury back in. Yes.
Just one other matter that Barbara West is the mother of the victim, Alan. And she is in the courtroom. She's not a material witness, but she may be brought in for punishment purposes if we get the punishment phase. I'd ask for her to be excused from this rule.
Judge, can we approach it?
Oh, I mean, either you want her, let's go on the record. All right, state, you're asking who be excused from the rule?
Barbara West, she is the mother of the victim. She was not at the scene. She didn't arrive at the scene, nor does she have any knowledge of what happened at the scene as an eyewitness account. She is solely the mother of the victim in this case, and she may be brought in for punishment purposes and not the first phase of this trial running.
All right.
Judge, I can't agree to that. We would like to invoke the rule. I can't tell the state how to try their case. They could use other people. So we're invoking the rule, please, Your Honor.
All right. Your witness is allowed to say she's not testing in the first phase of the trial.
That's right.
All right. She's allowed to say.
Well, Well, Your Honor, in that case, based on the court's ruling, can Mr. Castro's parents come in because they're only anticipated to be punishment witnesses if we get there, and I've just told them to leave.
All right. Do you have any objections, state?
No.
All right, the state is saying that they have no objections to his parents being allowed in the room because they're only going to testify in punishment if we get there. Is that correct?
Correct, Judge.
All right, so do you still have an objection to the complainant's mother being present?
Well, the court's already ruled, Judge. I'm going off, yes, I do, Judge, but I'm going on the court's ruling. I'm not waiving that objection, Judge.
No. Here's the thing. I'm just asking questions.
Yeah, I maintain my objection. I respect the court's ruling.
All right. No, the deputies wanted it changed for security issues. And are you Mr. Ruiz? All right, we're here on a motion to unseal documents, motions, and orders that were sealed. State, have you had a chance to review the defense's motion? All right, so defense is asking for.
First,
Sure.
make an objection to the use of the YouTube during this hearing.
All right, that's denied.
No, Your Honor, may I give my reason on the record?
All right, do you have an order? I mean, sorry, do you have a motion?
I have a motion and an order.
All right, do you
No,
have
no,
a motion that's
this
been
is-
filed? All right, so state, do you have any objection to an oral motion?
It's been heard. I believe there.
It hasn't been
some
heard. The
kind of-
motion to refuse. I'm sorry.
This issue has been heard. I believe there was a written motion previously, but it was ruled on. I don't have an objection to her re-urging her motion.
All right, you can re-urge your motion.
And Your Honor, it has never been heard. I asked, Your Honor, I asked you to recuse yourself
That was-
only for the purpose of the YouTube. That was the only reason I did it, and it was refused, but.
All right, and that was denied by a previous, by another judge, correct?
Yes, because I couldn't prove it under civil procedure. However, I'm requesting and objecting right now because my client has a presumption of innocence, which has been discouraged by showing him in prison clothes in front of a live audience of over maybe 1 million people. I don't know, but his presumption of innocence has been damaged because of this YouTube experience.
All right, that's denied.
Would my client sit in the jury box so he wouldn't be in front of the YouTube?
I mean, we're here on a motion, so he's here, or either he can sit at the table. He can either sit at the council table or he can stand here.
He considered council table.
All right, so y'all go back and sit at council table.
Expert.
Microphone on, I could,
I'm sorry.
there's a little bit of distraction. I didn't hear the name, Ms. who?
Does that work, Ms. Carrero? You have to. Oh, when I'm talking, okay.
I didn't hear the name of
Okay.
the person you said co-counsel.
There are, my co-counsel is. Oh, it just stayed on, okay. My co-counsel is Lorraine Efron, and she filed motions, I know, for fees for the various people that are attached to our case. And I'm
So,
reasonably sure that
just
was
one second.
October 31st.
Just one second. So let's start with this first one you're talking about. October 1st, 2023. Is that a motion that the defense filed that you want unsealed?
Not necessarily, when I found out it is a defense. Unfortunately, Your Honor, what we received on the computer, and I made copies for myself, not for anybody else. But when I received on the computer, mentions a motion and order filed. I don't know who files it. We don't always know. Miss Mitchell has been helpful as much as she can be, but I'm not sure. The reason for this particular motion to open unseal was because of when the plea was entered.
No. Let me stop you. This is my question. So October 31st, 2023, are you asking that motion, whatever it be, even if it's a motion that was filed by the defense for your expert or whatever, you want it unsealed?
Yes, Your Honor.
State, do you have any objection to unsealing a motion that was filed on October 31st?
No.
And to the clerk, are you able to look and see who filed that motion? What I will do, state, if you have no objections, I will grant the motion to unseal the motions that she's asking to be unsealed. and I'll do an in-camera inspection because I don't know what these motions were sealed as to. I don't know if it's something that everyone is supposed to see or not, because I don't know what it is.
Here.
Yes, he would need to be here. If these are motions that you're asking to be unsealed and they're in the co-defendant's case and it's motions that that defense attorney has filed on behalf of their client, you may not be entitled to have those motions unsealed.
Is that a ruling, Your Honor, or are we gonna have another hearing on this?
Oh, we're going to have a hearing and Mr. McCray will be here. And Mr. McCray may have an objection to the unsealing of motions that were filed in his case, perhaps by him, perhaps by the state. So this is the court's ruling with regards to the October 31st, 2023, November 1st, 2023, November 15th, 2023, November 16th, 2023, and November 22nd, 2023, and any other dates unknown to the movement. Court is rescinding any rulings that were made previously because the court assumed that these were documents that were filed in your client's cause number and not the co-defendant's cause number. So what will end up happening is the attorney in that case will be here, and that attorney can raise objections if he so chooses to having documents that he may have filed on behalf of his client and their cause number.
What I was quoting you was all their cause. It's the same cause number, it's just an A or B difference.
No, but here's the thing. If that defense attorney, Mr. McCray, filed sealed motions for his client, it may be experts for his clients, and he may not want those unsealed. And the question becomes whether or not you are allowed to unseal or have unsealed sealed motions that he has filed that, for example, if he hired an expert for his client and he does not want the state or you to know what the findings are of his experts, he has the right to keep that sealed. So he needs to be here to see if he has any objection. And I made my ruling previously thinking that these dates were dates that were under your cause number, but the state is telling me that these are dates under the co-defendant's cause numbers and not your own.
That's true.
Oh, well, then Mr. McCray needs to be here.
Probably for the next one as well. I'm asking for a copy of the PSI for Katrina Mendoza.
No, with regards to the PSI, Mr. McCray has no ability to object to your seeing the co-defendant's PSI. That is an order that you need to have heard to see if probation will allow you to view that.
I have to file another motion in order on that?
Yes.
Thank you. The other thing I'm asking for is a transcript of the witnesses that the state intends to call at time of trial.
What transcript?
Transcripts of the statements. The child who was a sister of our decedent Mercedes Lozoya is listed as a witness.
Well,
We'd like her a transcript of that, as well as anybody else they're going to call as a witness.
when you say transcript, was there a testimony or you're talking about them speaking to the police?
Voluntary statements.
All right, if they have statements, it should be in your discovery.
It's not just, we did not get a copy at all of young Jordan's. She was 6 years old at the time. I believe she's about 8 now.
It's a forensic interview, Your Honor. The disc has been in the file. The state has given defense counsel, actually, I brought the file down to court for multiple days for defense counsel to view with a separate clean computer.
Yes.
We've made it accessible.
But yes, technically they did, Your Honor, along with 3,000 plus other evidence of discovery. Personally, I put in close to $200 hours out of court, just me. Lorraine Efron has a whole nother bunch of hours. Out of that, I would like to request a transcript of Jordan's, rather than just her testimony, a transcript of it. Voluntary statement.
All right, so let me ask you this. This statement made, this alleged statement, was it made in English?
It's made in English. Yes.
All right, then you all need to view it. The state has given you opportunity to view it. I know that in this court, and if I'm wrong, correct me. I think during the holiday, I want to say November, Thanksgiving, I had the deputies have your client brought over and for you all to watch the video. So I'm not ordering them to transcribe a video. You need to watch it with your client. And the court has made the courtroom accessible for you all to do that. I'm not going to order them to have somebody transcribe a video that is in English.
Your Honor, excuse me, but we were never presented in court, and I thank you for the time you did give us, but for over 3,000 bits of discovery, which is it's 2 inches thick. When we ultimately file our 3914 motion, when we ultimately file, it's about 2 inches thick. We did get to see videos. We got to see certain statements. We never got to see Jordan's. We have to go to the office to see that. I'm requesting an actual transcript of her voluntary.
All right,
statement.
that's going to be denied for them to do a transcript. Deputy Mejia, is he able to come over here Wednesday to view a video? They will bring him over Wednesday to view a video.
Of Jordan.
There's multiple, I can bring them all over.
All right.
In particular, that one.
She just wants Jordan's. Is that correct?
That's fine.
No.
Had an opportunity to view the statements.
Now, my question is, do you just want them to bring Jordan's statement over?
That's fine. Yes, Your Honor.
All right, so she just wants Jordan. And Mr. Ruiz will bring you back Wednesday and you can see the video.
Your Honor, I have two other things that are not, one of them is from an order that Judge Harrell granted back on August 28th. It was about the medical examiner. She was subpoenaed pursuant to that order to be here on a given date, and she didn't show up. She had some other reason. She sent instead a pile about 1 inch thick of papers that weren't sealed, not sealed, but were not attached with a rubber band. And when I was reviewing them, I realized there was no certification of the records custodian as to the validity of those documents. So I'm going to do myself, with your permission, write a letter and ask for this custodian to send us another packet that has been notarized. If you're all right with that.
Oh, I'm not in charge of that at all.
Your Honor, I do have a brief response to that, just because Dr. Molina is, she's very responsible and she does stay on top of her things. She was in contact with me that day, and she had prior obligations, but she did send her assistant with all of the documentation that they had to, it was just a subpoena to bring documentation, Your Honor.
Mhm.
They brought the documentation, and then when we were conferring just in court, that it was acknowledged that really they just need Dr. Molina for a 705 at trial. So that's why she did not appear.
But we tried to do it beforehand in the interest of economy of the court. Even still, the fact that the documents were presented loose with no certification by the records custodian, how can we possibly use those records? I'm just asking that we get another copy certified by the records custodian before we go to trial.
All right, I'm not going to order that. If you all want something, you just pick up the phone, call the ME. You said you've already subpoenaed her in the records, then that subpoena is still in place.
Thank you. And one other thing, Your Honor, you referred, because I wasn't in this case until a year after it began, and I would like to get a copy of judge's notes in the file with your permission.
Sure, here's the docket sheet. The notes are on there. And this
It's
record
not
is
the
public.
same as, excuse me, Your Honor, I don't believe it's the same as the actual notes that are in the file.
This is the entire file. This is the court's, this file here. This is the court's file. I don't have anything else.
You
If
didn't
it's
write
not in this
anything?
file, it doesn't exist.
There's nothing written in the file, in other words. It's all on that.
It's
those
the
pages.
docket sheet. I write everything down on the docket sheet, and any orders or motions or any letters that have been received from the jail by your client, it's in here. This is the court's file.
So if I can get a copy of that, you're talking about.
Oh,
the
we're
docket
not,
sheet.
here's the thing. We're not going to have the copy machine at back and use the copy machine for you to make copies on this. You're more than welcome to write down whatever you want to write down from it. you're more than welcome to do that.
Can I send somebody to do that? Or can I send a records copier company to come and copy them?
Here's the issue with that. This is a legal document. This document, this file, the custodian of this file, technically and legally, is the district clerk's office. So you would have to clear that with the district clerk office if they would let some outside party come in, take this file apart and get copies of it.
But in there is the year before I was appointed. It has all the comments that the court made. Is that correct?
What is in here is what is in here.
February 7th was the arrest date. It's the date of Mercedes' death. I was appointed and actually activated in April 2nd. There's that whole year took place. Lorraine was replaced by Debbie Burke, who was hired and then withdrew. Debbie was in, Mrs. Burke was involved for 9 months. I don't know what happened during that time. I don't know what orders the court made. I don't want to run afoul of anything.
It is on the docket sheet, and any motions that were filed that are not under seal are in this file. And anything, any orders that were heard are in this file. If it's not in this file, that means that it's not in this file and no order was heard.
Okay, thank you. And can I have the same access to Katrina Mendoza's file?
I'm not in charge.
Technically, they're all.
Here's the thing, and I want people to hear me clearly because maybe I'm not communicating properly. These files are the court's files. And when I say court's file, I don't mean they're Stephanie Boyd's files. I mean, these are the files to the 187 District Court. The custodian over these files are the district clerk. If anybody wants some inside party to come in to copy this file, you need to speak to the district clerk about it and see whether or not they are allowed to come in to make a copy of the file. I am not the custodian of the records of the file. Do I write things in the file on the docket sheet? Yes, I do, but I'm not the custodian of records. So if you want to bring some third party in to make a copy of John Doe's file, Amy Doe's file, whoever it may be, that needs to be cleared with the district clerk's office because they are the custodian of records of these files. I am not.
Okay.
And what I can tell you is the normal practice in this court, if there is a hearing held, if I give a ruling on something, I write it on the docket sheet. That's where we are.
All right, who is Roland under Roland's iPhone? And who is one word plus? Oh my gosh. Is this an attorney? Why doesn't he have on any clothes? Who is this Roland person? Does anyone know who that is? All right, Roland under Roland's iPhone, you are not allowed to be on Zoom anymore.